Hi friends, today we'll discuss about recording of evidence. In recording of evidence, we'll discuss about different steps taken in the court of law to record the evidence. After receiving a subpoena, also known as summons, the witness must appear before the court on the appointed time and place to get recorded the evidence. So different steps taken to record evidence include oath, then there is examination chief, then cross-examination, re-examination and court questions. Coming to one by one, the oath. It is a declaration required by law to be made before the court by the witness. So every witness who comes to the court has to take the oath. The oath is that he has to swear in the name of the God that he will tell the truth, the whole truth, and nothing but the truth. So if the person is religious, he will swear in the name of the God. But if the person is not religious, then he will solemnly affirm that he will tell the truth, the whole truth, and nothing but the truth. If the person after taking the oath tells false, then it becomes a perjury. So perjury is a witness who after taking oath willfully makes false statement which he knows or believes to be false. When he knows it, that is what he is telling is false or lies, even then when he tells, that is considered as perjury. By law, it is punishable under section 193 IPC up to 7 years and fine. So if he tells false statement, then it is punishable by law. Now coming to examination in chief, this is done by the counsel side or the person who has summoned him. The lawyer who has summoned the person does the examination chief. That is the first step in taking the evidence. In this, the objective of the examination chief is to present all facts of the case before the court. So all the facts that the witness has to give is extracted by the lawyer by an examination chief. If the witness is expert, that is like a doctor, for example, a doctor, then he is asked to assert his interference from the facts. So, for example, if he may be given some certificates taken from other doctors, and he may be asked to opine on that certificate. In this examination, no leading questions are asked. So, leading questions are those which suggest the answers from the question itself. Again, I will tell about leading question in next slides. So if we take an example of examination chief in a scenario of penicillin injection, the lawyer will ask doctor what precautions are necessary before injecting the penicillin. So before injecting, what are the injection should be taken, precautions should be taken. The doctor will answer, a sensory test should be done. So if thought in sensory test, if penicillin injection taken, an infectious reaction is to happen. So doctor will answer, sensory test should be done. So this is just a direct question that what precaution should be taken and the direct answer given by the doctor. In cross-examination, it is done by the opposite party or defense lawyer. Then the objective of cross-examination include to elicit facts favor to his case, to test the accuracy of the statement made by the witness, modify or explain what has been said. So here the objective of the defense lawyer is to make the what are the statement made by the doctor or expert or witness to be different. Okay, so what are the facts favor to his case? So he only extract the answers from the expert favor to his case to test the accuracy what he has told and to modify anything which he has been said. Then he has to want to know to develop new or old facts. He may make the questions so that he will discredit the witness to remove any overemphasis which may have been given to any fact or on direct examination of examination chief. So these are the objective by which the lawyer will go for cross-examination. In cross-examination, there is no time limit and it can last for hours to even days. The court has a power to allow questions which are indecent or scandalous or intent to insult or annoy or offensive form. So cross-examination can last for many days, hours to days, and the lawyer, the judge has the power to remove certain questions which are indecent or scandalous. Witness may also ask lawyer to understand the question better because he may get confused which question he is asking and he may require clarification. In cross-examination, leading questions are allowed. So in examination, if leading questions are not asked, are not allowed. In cross-examination, leading questions are allowed. So leading questions are questions suggesting the answer from the person which he wished or expects to receive. So here he is suggesting the answer in the question itself. So it includes facts or admits conclusive answer by a simple yes or no replies. For example, was the length of a incised wound was 15 centimeters? Here, the lawyer himself is telling the answer that the length of incised wound is 15 centimeters. The doctor just has to answer whether it is yes or no. Instead of asking what was length of the incised wound, he himself is giving the answer. He is suggesting the answer himself. These are called as leading questions. Leading questions can be asked when witness becomes hostile also. So hostile witness is one who is willfully gives false witness. So hostile witness is one who gives willfully witness against the person who has given the evidence. So hostile witness, which we have discussed in previous videos, so is the one who is willfully gives false evidence about certain facts and against the person who has summoned him. So this is taking the same scenario as penicillin injection. The lawyer may ask, doctor, is it possible that anaphylactic reaction may still occur even though the sensitivity test is negative? So this is one of the leading question. The lawyer is asking to the doctor that whether the anaphylactic reaction is occurs even the sensitivity test is negative. So here the answer is obviously yes, because sometimes even then sensitivity test is negative, sometimes anaphylactic reaction may occur in the person. So here the objective of the lawyer of the opposite party is to make the answer given by the first examination chief to discredit him. Next is re-examination. Here, examination of witness subsequent to cross-examination is by the party who called him. Again, the person who has summoned the witness again does the re-examination. The objective is to make clear any doubts that may have arisen during cross-examination and to explain some matters in proper perspective to avoid possible misinterpretation. So here the objective of the person of the lawyer is to make the sentences any doubts which have arisen and also to make the sentences which the doctor has told to properly explain so that there is no misinterpretation. Again, the opposite lawyer has the right to cross-examine the witness. So this cycle of examination in chief, then cross-examination, then re-examination. This goes on in a way of cycle, so that this goes on like that for each every time there is a doubt arises, and this may go for few days to few hours to few days or months. So this is the example of the same scenario of re-examination where doctor, what would be the difference in, the lawyer will ask what would be the difference in anaphylactic reaction in case where the test was positive and another case in which test was negative. So here the objective of the lawyer is to clarify the misinterpretation what was given in the cross-examination. Then the doctor will reply, in the former case it would be far more severe, in the later case it would be milder. So if the sensitive test is negative and there is anaphylactic reaction, it will be milder compared to where the sensitive reaction is positive. So here the lawyer has clarified the doubt which may have arisen that even if the sensitivity test is negative, if injection is given, if the reaction occurs, what happens? So that is clarified by the lawyer in re-examination. Then fourth step and last step is court questions or questions by judge. These questions can be asked anytime. So it can be asked anytime during all the three steps, that is examination, cross-examination, re-examination. So judge may ask this question anytime to clear any doubts which have arisen in his mind. He can call witness anytime again for his evidence if needed by the court related to the same case. He can ask the evidence any questions and he can call the evidence anytime for same case. So if there is any doubt, the judge may ask in the same scenario as if we take example of penicillin injection. Doctor, is there no way of which one can be absolutely certain is sensitive to penicillin or not? So the doubt which has arisen in the judge that whether there is any perfect solution for the sensitivity test, then the answer is the doctor can give is no, because there is no perfect way of knowing whether the person is completely sensitive or not. So these are my references. I hope you understood about recording of evidence. Thank you.